Chairman Ashton Burrell of the New Jersey Human Relations Council.
Mute me.
Because did you guys hear me?
We can hear you now, Ashton.
Oh, you didn't hear me before?
No, sir.
Oh, sorry. Well, I want to say again, welcome to everybody that came out today to our December 1st Criminal Justice Reform Conference from the New Jersey Human Relations Council. I want to thank the whole team that has made this possible. I also want to thank our New Jersey Human Relations Council team, my Vice Chair, Yumiko, as well as our executive officers, Karen, as well as Claudia and Bryn for making things work.
Ashton, you're on mute and your camera is off. There you go.
Sorry about that. But I just want to thank everybody for joining us. It made me think about a quote from Charles Bukowski that says, the only time we think about an injustice is when it's happening to us. But that seems to be a different case for everybody that's on here today, because people on here are concerned, and I appreciate you guys. I have the honor of bringing forth dynamite speaker, as well as a just general person in the state of New Jersey and throughout the tri-state. The Honorable Glenn Grant was appointed by Chief Justice Stuart Rabner as the director of the New Jersey Administrative Office of the Courts on September 1st, 2008. Under the leadership and direction of the Chief Justice, he provides the day-to-day management of the court system. He collaborates with the Chief Justice to oversee the court staff of 9,000 plus employees, including 460 superior court judges. He is also responsible for overseeing the state municipal courts, comprised of approximately 350 municipal judges and 2,500 administrative staff. The administrative director is a constitutional position, and Judge Grant is the 8th person to hold the position and the first minority appointed to the lead of New Jersey's court system. He joined the bench in 1998, serving as a family judge in Essex Vicinage. Prior to the appointment to his current position, Judge Grant served as a presiding judge of the family apart. He was temporarily assigned by former Chief Justice Poritz to serve as acting chief judge of the Newark Municipal Court in order to address management and other operational issues. The administrative director, Judge Grant, serves as a member on the Judicial Council, the policymaking body of the New Jersey courts. He chairs or is a member of several New Jersey Supreme Court committees, which include Access and Fairness Committee, Advisory Committee on Information Technology, Minority Concerns Committee, Domestic Violence Committee, Children in Court Committee, Juvenile Detention, Alternative Initiative Committee, and the Joint Committee on Criminal Justice Reform. Prior to his judicial career, Judge Grant served as a corporation counsel and business administrator for the city of Newark. He received his bachelor's degree in political science from Lehigh University and his law degree from Catholic University. He studied executive management at Harvard University's John F. Kennedy School of Government. And without further ado, I would like to introduce the Honorable Glenn A. Grant. Please welcome him.
Thank you, Chairman Burrell, for that kind introduction. and welcome to all the members of the New Jersey Human Relations Council. I'm here on behalf of what I consider to be the best branch of government. For you who don't know it, there is an executive branch, a legislative branch, but in my humble opinion, the New Jersey judiciary is the best branch of government. You can please make sure that you record that. You can share that with the members of the legislature, members of the executive branch, but that's who we are. And I want to celebrate and acknowledge the great and long history the New Jersey judiciary has, a really long legacy of critical self-analysis and focusing on expanding the doors of opportunity, increasing equity and fairness in our system. Just 3 weeks ago, the Supreme Court held a judicial conference on jury selection at the New Jersey State Bar Association's Law Center. In his opening remarks, Chief Justice Rabner compared the efforts to reform and improve the jury selection processes in our state to the need for the renovation and repair of an old building. The metaphor of an old building needing updating to maintain its grandeur has particular similarity to the work, in my opinion, of the courts. Obviously, our work is connected to more than a physical location. It is connected to the organizational culture and the reasons why society needs a strong and effective judiciary. It is connected to, in my mind, Dr. King's view on the bend of the moral arc of the universe and the special role that judiciary plays and performs in society. It is linked to the judiciary's guiding principles and character as to who we are and what we are. Now, our judiciary is more than 300 years old, and we have made both major and minor renovations to our building over that time. Some of you may be aware of the most comprehensive redesign of our building, which occurred with the passage of the 1947 Constitution. But what we sometimes fail to recognize is this ongoing quest for justice and fairness by successive chief justices and members of our Supreme Court. Those efforts are designed to advance equity and fairness in our system. In 1979, Chief Justice Willin said the following: "We," referring to the New Jersey judiciary, "are fortunate, for not only is our judicial system in New Jersey better designed, but by tradition, reform has been very much a part of it, much more so than other institutions. We are psychologically ready not just to accept reform, but to propose reform." And over the decades, the reform and renovation strategy for maintaining our building has remained the same, despite the issue or challenge. When necessary, the approach has been to overhaul, transform, or redesign our building to meet the needs of an ever-changing society. Where needed, the interior and exterior of our building has been revised by installing additional foundations and supports to advance justice, fairness, and equality. There's an extensive and nearly 40-year legacy of continuing self-critical examination and evaluation of our building through such efforts as the Committee on Minority Concerns, now known as the Committee on Diversity, Inclusion, and Community Engagement, the Committee on Women in the Courts, now also an advisory committee on access and fairness. These efforts also include the Task Force on Interpreting in 1980 and the Task Force on Lesbian and Gay Issues, which was established in 1995. These systemic reform efforts by the New Jersey courts have been and continue to be a critical means by advancing racial equity in the administration of justice. They have been a way of ensuring that our building is adjusting to the continuing demands by citizens and the residents of this state for a fairer and more just judicial system. Under the continuing leadership of Chief Justice Rabner, we have continued to advance the constitutional promises of equal protection and due process, not only through case law, but also through court operations, policies, procedures, and programs.
Let me tell you.
Ongoing efforts to maintain the structural supports for our building are aligned with the community's aspirations for an inclusive and diverse and fairer society. Our systemic reform initiatives are also characterized by interagency and interbranch collaboration, such as our participation today in the New Jersey Human Relations Council. We have become a national model, for example, in juvenile detention alternative, reducing the population of juveniles in our detention by more than 70%. We've had ongoing collaborations with the Juvenile Justice Commission to further advance and improve our juvenile justice processes. The Radnor Court has led very significant reform initiatives, including today's focus on criminal justice reform. As heard by Lisa, statewide pretrial service manager Nick Solomon will highlight key features of the New Jersey CJR model, but I want to set the stage for the understanding and the operational aspects of New Jersey's current criminal justice system model. It is valuable to note that the blueprints and the architectural drawings involved in our redesign of our state pretrial decision involves a collaboration and partnership with many. What you need to know is prior to January 1st, 2017, which was the effective date of the Criminal Justice Reform Act, New Jersey relied on monetary bails for most cases. The New Jersey state constitution historically guaranteed the right to monetary bail, which was designed to address the accused's risk of flight or failure to appear at a court event. Interesting to note, it did not include or address public safety concerns regarding a defendant's possibility of committing an act of criminality while out on pretrial release. We then recognize, as many other jurisdictions have now begun to recognize, the dual system errors of New Jersey's former cash bail system, which impeded both public safety and fairness. It was not based upon an individual's level of risk, but rather an individual's economic circumstances. And while lower individuals without economic means could be detained in jail for substantial periods of time, such a system led to disparate impacts on poor defendants while also not increasing or improving public safety. In 2013, a jail study revealed that monetary bail system had an especially adverse effect on poor defendants and members of minority groups. This study uncovered that poor individuals were greatly impacted, with 12% of the jail population in October of that date incarcerated for bails of $2,500 or less. Let me repeat that, of $2,500 or less. That meant that if the defendant couldn't afford $250, they would have to remain in jail for the extended period of time until their case was resolved. At the same time, there were significant abilities of people with access to money to get released from pretrial. Studies also show that there's a cumulative impact on defendants detained pretrial, including the loss of housing, employment, personal relationships, possible custody of their children. So what do? The Foundation for Reforming New Jersey Bail System has had and does have a number of key architects. The first architect, and I believe the most important architect, is Chief Justice Stuart Radnor, who formed the Joint Committee on Criminal Justice, which was comprised of representatives from all branches of government. The committee unanimously recommended a series of recommendations or reforms that served as the blueprint for criminal justice reform in our state. On August 4th, 2014, another champion, then Governor Chris Christie, signed into law the Criminal Justice Reform Act, or CJRA. The act was to be effective on January 1st, 2017, but it was conditioned upon the approval of the residents of New Jersey to amend the Constitution to move away from a monetary bail system to an evidence-based and risk-based pretrial release system. In November of 2014, almost 70% of the citizens voted to approve that ballot question, thus securing the enactment of the right to pretrial release, pretrial detention, and the Criminal Justice Reform Act. After January 1st, 2017, there is now a statutory presumption for a defendant's pretrial release. The court must consider non-monetary bail conditions for a defendant's release before considering the posting of a bail. The use of bail was preserved in exceedingly limited cases, and its purpose was restricted to ensuring that a defendant appeared or attended all court events. The use of monetary bail has significantly declined since the inception of CJRA. In calendar year 2019, the court ordered 43 defendants to post monetary bails. In calendar year 2020, only 5 defendants had bail set as an additional hearing. Despite these reforms, pretrial recidivism and failures to appear did not increase. They remain substantially the same as before the implementation of CJR. New Jersey CJR system has almost entirely replaced a bail system while focusing on 3 critical areas. Number 1, increasing public safety by keeping in detention those defendants who are high risk and dangerous and not those without the economic means to be released. Number 2, protecting constitutional rights and liberties, such as balancing public safety with the defendant's right or presumption of being innocent. And number 3, addressing disparate treatment of criminal defendants based upon race, socio-economic background. In October of 2012, and in a comparison of the October 2018 jail population showed that almost all demographic groups have benefited from CJR. The jail population in 2013 revealed that more than 2/3 of the defendants held in jail were members of racial and ethnic minority groups. The 2018 population study showed that approximately 3,000 fewer Blacks, 1,500 fewer whites, 1,200 fewer Hispanics were being incarcerated as a result of the new pretrial release system. However, we cannot celebrate the entirety of our program. The criminal justice system still has work to do. Despite these overall reductions, Black defendants continue to make up 55% of the jail population. In 2019, 29% were white and 16% were Hispanic. The disposition was nearly identical in 2012 and 2018. Some of these disparities may relate to the charging decision. For example, 50% of the defendants issued a warrant that is transported to the county jail in 2019 were Black. Addressing this problem will require law enforcement and other system partners to address and examine disparities at the front end of the criminal justice system by examining policing decisions, filing of charges decisions, and decisions to prosecute before an individual encounters the court system to tackle this significant fairness problem. Now, I believe that we all have a responsibility in upholding the Constitution and the principles of fairness and equity, and also ensuring public safety. The work of improving New Jersey's criminal legal system and the administration of justice through the New Jersey court did not end with the implementation of CJR on January 1st, 2017. We continue to see related systems improvement, including some of which you will hear about today, to further advance the arc of justice, as Dr. King flagged. You will hear conversations about municipal court reform, probation services reform, and the statutory expansion of the expungement processes for eligible defendants. For me, the New Jersey Supreme Court remains a leader in ensuring equity through the administration of justice. These few examples show the court's continuing commitment to racial equity and social justice on a systemic level. In August of 2019, the renaming of the Minority Concerns Committee to the Diversity, Inclusion, and Community Engagement Committee was an updated and more inclusive charge for their work. In response to the tragic death of George Floyd on June 5th, 2020, a statement by the Supreme Court and Administrative Director on racism, systemic racism in society and in our judicial system. In July of 2020, an action plan on ensuring equal justice. And in August of 2021, a status report on the year 1 action plan and the announcement of the year 2 action plan. Important to note that we didn't just talk about addressing systemic barriers, we completed or addressed almost all of the 9 action points identified in the 2020 plan. And as I began our conversation, just 3 weeks ago, the convening of a judicial conference committee or conference on jury selection in order to further expand the opportunities for all segments of our society to participate in the jury process. Now, there have been other major accomplishments in our program, which time does not allow me to address. But we, as I indicated, the New Jersey judiciary has been focused and committed to renovating the foundation to our criminal justice building, to our justice building. We recognize that there is still much work to be done. But I would argue to all of you who are members of the Human Relations Committee that the work does not belong to any one of us solely, but to each governmental issue, each governmental agency, each governmental partner, the legal system partners, the attorneys, the members of the nonprofit community, and the larger community. Each plays a critical role in the advancement of equity and fairness in our court. I argue that this is a shared responsibility that each of us must embrace in order for a better, more inclusive society. For your information, New Jersey judiciary has also served as a national leader in advancing this question of equity and fairness in our court systems at the national level. 30 years ago, we became a co-founding member of a national consortium on racial and ethnic fairness in the courts. Today, the New Jersey judiciary continues to play a leadership role through engagement of a range of national initiatives, including the Blueprint on Racial Justice in the State Courts, which is led by the Conference of Chief Justices and the Conference of State Court Administrators. Let me close with where I began by paraphrasing comments made by Chief Justice Rabner at the Judicial Conference of a few weeks ago. He maintained that the work of reforming, improving our figurative building must be about more than creating aspirational blueprints, but rather through collaboration and communication, creating a focus and a dedication on renovating our building in order to sustain and enhance that 7-letter word called justice. We are a proud member of this council. We are a proud member of the work of advancing and improving our organization. And we look forward to working with the members of the council and the other attendees to this presentation to further advance those initiatives. Thank you very much.
Thank you very much, Judge Grant. Thank you for opening the program with a history of sustainable systemic change here in New Jersey, for the history and framework of criminal justice reform, and for the acknowledgement of the reality of continuing disparities in outcomes that are marked along the lines of race and ethnicity. For those I have not met yet, my name is Lisa Burke. I'm the Judiciary's Diversity, Inclusion, and Community Engagement Program Coordinator, and will be serving as the facilitator for the remainder of this morning's conference. Next, I would like to introduce my Judiciary colleague, Nick Solomon. Nick is the statewide pretrial services manager and will be providing highlights of the key components of the criminal justice system here in New Jersey. Nick.
Thank you, Lisa, and thank you to the Human Relations Council for having me here today. And thank you to Judge Grant for having me here today by naming me the Chief of the Pretrial Services Unit. And I could not have asked for a better tee up to my presentation today than the words of Judge Grant. I'm going to be sharing a PowerPoint with you. I believe you can see it now. Let me start by saying that this is going to be a broad overview. At the end of this presentation, I will drop my email into the chat so that if you have additional questions or your agency wants to reach out to us, please feel free to. We're always aimed at advancing criminal justice in the state of New Jersey and throughout the country. So today I will be covering the key elements of the Criminal Justice Reform Act. And there we go. Before we begin with that, I think it's important to understand the definition of who is covered by the Criminal Justice Reform Act. There's 3 categories of defendant. The first and foremost is a defendant who is charged on a complaint warrant for an initial charge involving an indictable person's offense, an indictable offense or a disorderly person's offense, and who is arrested on or after 1/1/17, as Judge Grant stated, is eligible and covered by the Criminal Justice Reform Act. If you're charged on a summons, you're not eligible, you're handed your summons, you're sent home. Once you get into who's eligible for criminal justice reform, there's 2 subcategories. There's defendants who are eligible for detention and those who would not be eligible for detention. Only defendants who are charged again on a complaint warrant with an indictable offense or a disorderly person's offense involving domestic violence are even potentially eligible for detention. And as the Judge Grant stated, there is a presumption of release in the majority of cases. So even though you're eligible, there's still a presumption that you should be released on some sort of conditions. The pillars of criminal justice reform, as I went through the act to prepare for today, I was able to break it down into really 5 key pillars. That we make risk-based release decisions, that there's the use of preventative detention for high-risk defendants, that there's the use of evidence-based tools, and in New Jersey, that's the PSA and the DMF. And by evidence-based, we mean objective, data-driven, and scientifically validated tools. That there's monitoring pre-trial services, and that there are now strict speedy trial deadlines. The legislation, as Judge stated, was effective on January 1st, 2017. The Criminal Justice Reform Act provides for a presumption of release. Release decisions must be made within 48 hours of detention to the county jail unless a motion for pretrial detention has been filed. When releasing a defendant, the goal is to craft conditions of release that ensure the defendant will appear in court when required, will not commit new criminal activity, and will not obstruct or attempt to obstruct the criminal justice process. Conditions should be the least restrictive necessary to meet those goals. We must use a risk development tool that is objective and data-driven. The judiciary was required to create the pretrial services program. It was a whole new division that did not exist prior to the creation of the Criminal Justice Reform Act. The pretrial services program is responsible for running the risk assessment and making recommendations to the court, and for monitoring those defendants who are released pre-trial. It created the preventative detention prior to criminal justice reform. As Judge Grant stated, there is a right to bail for nearly every single defendant. So John Gotti commits a couple murders, but has enough money in the Cayman Islands to post a bail. He had a right to bail and he could be released. With the passage of the Criminal Justice Reform Act, that completely changed. However, it should be clear that detention is only possible when the prosecutor makes a motion for pretrial detention. The court cannot in and of itself detain a defendant. And finally, there were speedy trial deadlines for those who were detained pretrial. And you're going to be saying to yourself, I understand that there was always speedy trial right in the Constitution, and that is correct. But prior to the Criminal Justice Reform Act, that concept was amorphous in nature. There were not strict and solid deadlines. So first and foremost, what is a risk-based system of pretrial release? Judge Grant kind of went into this before, but to understand what a risk-based system is, you have to first understand what a resource-based system was, and that was bail. So the only thing that mattered is how much money did you have in the bank? If you had enough money, you could post your bail, you could get out regardless of your charge. Going back to my example of John Gotti, he commits a couple murders, but has the money to post bail. He's walking the streets regardless of his risk to the community. Meanwhile, John down the block, who lost his job and might have a substance abuse problem and addiction, can't post $250 to get out of bail and will sit there regardless of the fact that he is no risk to society or to his community. What we did instead is go to a risk-based system, and that minimizes those dual system errors by objectively measuring a defendant's risk of failing to appear and risk of committing new criminal activity, and allows us to detain the highest risk defendants, release moderate risk defendants with interventions and services targeted to mitigate risk, and release low risk defendants with minimal or no conditions. And however, let's be very clear, and as Judge Grant is keen to say, no system will ever be able to guarantee that every defendant will come to court and obey the law. However, while not perfect, the risk-based pretrial release system can deliver better pretrial outcomes than a monetary system because it measures and it manages risk. It's not based solely on how much money you have, but the risk that you potentially are to the community and to failing to appear. And again, it allows us now to detain high-risk defendants while releasing those low and moderate risk defendants using the least restrictive conditions necessary to ensure success. As Judge Grant has eloquently stated, New Jersey's pretrial system is two-pronged, not one. And we almost always hear about the one prong of releasing defendants. But the goal of the Criminal Justice Reform Act is not only to release low and moderate risk defendants, but to detain high-risk defendants whose risk to the community cannot be appropriately mitigated or managed on release. That leads into the second prong, or the second key element of the Criminal Justice Reform Act, which is the creation of preventative detention. an option that just did not exist prior to the CJRA. Our Constitution was amended to allow for pretrial detention. Before detention can occur, the prosecutor must file a motion for pretrial detention. As I stated earlier, the court in and of itself cannot detain a defendant. After the motion is filed, the court must hold a hearing on that motion. It must be heard within 3 business days. The defendant must be charged with an indictable or a domestic violence related disorderly persons offense to be eligible for detention. And only if the judge is not satisfied that the defendant can be safely released based upon clear and convincing evidence, may the judge then detain the defendant. The majority of cases, there is the presumption of release, but I do wish to highlight that in 2 specific instances, that presumption does switch. If a defendant is charged with murder, or if a defendant is charged with a crime that subjects him to potentially life imprisonment, the presumption then becomes a presumption of detention and is the responsibility of the defendant to overcome that by preponderance of the evidence. And even if the defendant does overcome by preponderance of the evidence, then the state can still show by clear and convincing evidence that no amount of monetary bail or non-monetary conditions or combination thereof will ensure the defendant's appearance in courtroom required, that he will not commit new criminal activity, or that he will not obstruct or attempt to obstruct the criminal justice process. All of this could not be done unless we were using these evidence-based tools that were developed. The judiciary worked with the Laura and John Arnold Foundation and Dr. Marie Van Nostrand to develop the Public Safety Assessment, or the PSA, and the Decision-Making Framework, or DMF. The Public Safety Assessment is objective, data-driven, and scientifically validated in what was and probably still remains one of the largest scientific research projects in the country when it comes to risk assessments. There's a version of the PSA that can be run by law enforcement to help them make a decision on whether or not to seek a warrant or a summons. It can then be provided to the judge if they are seeking a warrant, so the judge has more information. If the defendant is arrested on a complaint warrant and committed to the county jail, the pretrial services program will then run the public safety assessment. It will be provided to the judge, the prosecutor, and the defense attorney with the objective, data-driven information about the defendant's risk level. And when I continue to say objective and data-driven, what I mean is the PSA is only concerned with the defendant's criminal history. It does not know anything else about the defendant. It is blind when it comes to the defendant. We input criminal history, it exports a score. So it is objective. It's not how long has the defendant lived in the community. It's not those old Johnson factors that you may have heard about being used. Those are things that counsel can still argue, but the risk assessment itself is blind and it is only concerned about prior criminal history. And it's also important to note the PSA is not the decision. It is a tool that is provided to the judge and to the stakeholders, providing them information and risk measures to be used in making the release decision. Once you run the PSA, the scores themselves are only semi-useful. So then we go to the next step, which is the decision-making framework. It considers the PSA results along with the current charges and provides a recommendation to the court. This ensures that there's a statewide consistency in pretrial recommendations rather than one county believing that a 2-2 scoring would mean release, while another county would think a 2-2 score might be detention. So we've ensured statewide consistency by using the DMF. The PSA, as I stated, provides judges, prosecutors, and defense attorneys with objective, data-driven information about the defendant's risk level in 3 categories. The risk of new criminal activity, which is scored on a scale of 1 to 6. The risk of failing to appear, which again is scored on a scale of 1 to 6. And the risk of new violent criminal activity, which is a yes/no answer. On the PSA itself, there would be a flag or no flag. And the flag appears once the defendant hits a certain threshold of risk that he would commit future violent criminal activity. And you can find more information on this at www.psapretrial.org /about/what is PSA. The decision-making framework is meant to manage the risk. So now we know the risk based off the PSA, but what do we do? It reflects the jurisdiction's risk tolerance and resources. It's policy based on data and evidence. Again, it considers the PSA results, the FTA scale, NCA scale, and the flag, and the current charge. And it identifies a proposed release detention recommendation designed to manage risk in the most effective manner. And these are some of the risk or recommendations that can be made. Release upon one's own recognizance, release on conditions of release, either level 1, level 2, level 3, or home detention, apologies, or no release recommended. The DMF is meant in part to manage the risk and to account for those outside events where you have a defendant with no criminal history, but who comes to the court on a murder charge. When you run the PSA, that defendant will score the lowest of the low, a 1 and a 1. However, because it's a murder charge, the 1-1 isn't controlling. We need to look at what that current charge is as well. And then based on data and evidence, what is the recommendation we need to make to the court in those cases? The fourth prong of the Criminal Justice Reform Act was the creation of the Pretrial Services Program. The Administrative Director of the AOC, Judge Grant, was required to establish and maintain a pretrial services program throughout the state. The pretrial services staff are required to monitor defendants who are released on conditions as ordered by the court. So the court order is the controlling document. Whatever is in that order, the pretrial services program must enforce. We cannot make other conditions, and they cannot ignore conditions that the court has ordered. Although the pretrial services staff are tasked with monitoring pretrial release defendants as judicial officers, it's important to note they're not law enforcement. They are part of the court. They are a resource of the court. And the main goal of the pretrial services program is to remind the defendant of their court appearances and to be a resource for that defendant. At the end of a case, if the defendant has appeared for all of his court appearances and has not committed new criminal activity, that defendant is a success in the eyes of the pretrial services program. Finally, the fifth element of the Criminal Justice Reform Act, or key element, is the speedy trial provisions that it created. As I stated before, there's always been a constitutional right to speedy trial. However, that was an amorphous term without clear-cut guidance and edges. CJR created clear-cut timelines that must be met by the state, by the court. A defendant who is detained pursuant to a pretrial detention or release revocation order, or who is detained in jail due to the inability to post monetary bail set as a condition of release is subject to speedy trial. And as Judge Grant stated, there's very, very few defendants now who are in jail on bail. There are 3 different speedy trial time standards. Pre-indictment, an indictment must be returned within 90 days of detention, not including excludable time. And unfortunately, excludable time is a whole other presentation that would take hours to go through. So I won't be able to define it here today. Post-indictment, the trial must begin within 180 days of the return of an indictment, again, not including excludable time. And finally, there's an overall 2-year clock in which the prosecutor must be ready to begin the trial within 2 years of the date of detention. And this is only not counting delays attributable to the defendant. And this was to ensure that delays attributable to the state or to the court for discovery or state motion practice or things along those lines, that the state's fault would not continually keep a defendant in jail indefinitely. And again, this was to create finally a solid speedy trial deadline, which did not exist prior. And it was kind of the balance of, if you can now detain a defendant pre-trial, well, then we need to give them a right and an ability to not stay there for years upon years. So that is criminal justice reform key elements in a nutshell. Again, I'm going to drop my email into the chat if you have questions, or if you would like to speak further on this topic or need a presentation for your committee or group, please do reach out to me. Our goal remains education and outreach to ensure that people understand criminal justice reform and to explain how it has benefited not only our state, but how it can benefit the country as a whole. Thank you.
Thank you very much, Nick, for that informative overview. I am going to present one question to you before you exit the virtual stage. You spoke a lot about the objective nature of the public safety assessment and the decision-making framework. Some of our conference guests have a question on their mind, though, regarding the literature that argues that algorithms used in risk screening tools generally are biased and often biased against people of color. Could you speak briefly to that?
So there has been some literature on that topic. What I can state, however, is that New Jersey spent years developing the risk assessment tool. When I say this is one of the largest research projects that was done on this topic, we went across the entire country to review thousands of potential decision criteria when making these risk assessments to make sure that we picked the most important risk points that highlighted the true nature of risk of a defendant while minimizing the impact it has on the minority community. Again, is anything perfect? No. We are continuing and will always continue to review conditions and look into this and to adjust as necessary. But this is light years better than what we had prior, which again, did not take risk into consideration whatsoever and was only concerned with resources. And as Judge Grant stated, that had an immense negative impact on our community, our minority communities across the state.
Can I add my voice to the question? And I think Nick has eloquently outlined some of the reasons why we think our system works even better than others. Number one is our system is a dynamic system. That is, the use of a pretrial assessment tool is constantly in flux and constantly developing. As Nick described, it's based upon actual history. So I think what people have to understand is, while there has been a history of systemic problems in our society, every court system is going to rely upon a person's prior criminal history to determine his or her release. And what New Jersey has done, this is not the New Jersey judiciary, is really a testament to the great collaboration between the three branches. Just use marijuana expungement as an example. By the collaborative support of the three branches of government, New Jersey has removed marijuana convictions and expunged those marijuana convictions from a defendant's record. So now when you run a public safety assessment, a marijuana conviction is not considered and has been removed. And we've removed about 360,000 of those convictions from our record. Number two, we're also exploring changes to our public safety assessment on an ongoing basis. Right now, we're exploring failures to appear. Is failures to appear over a long period of time relevant to a defendant's perspective of appearing based upon the last 2-3 years of history? And we're in the process of amending our tool to reflect a more refined process by which those failures to appear will be done. But I would conclude with what Nick reminded. No criminal justice assessment is going to say you have been convicted of the following offense, and because you are Black, because you're Hispanic, we're not going to consider that conviction. It is the person's prior conviction. And New Jersey system does not consider arrest in terms of trying to assess whether a person should be detained or released. So we believe that the analysis on some of the old or other pretrial assessment tools are remarkably different from New Jersey's tool. And we would say that it stands up to the test in terms of fairness, in terms of equity, and making the system fair for everybody.
Thank you very much, Judge Grant. There's some conversation in the chat, regarding the impact that considering criminal history has. We just want to make sure that the attendees understand the unique approach New Jersey has taken with extra diligence to really ensure there is minimal impact in terms of those systemic disparities. But as Judge Grant noted, it's a dynamic process, and there's continuing reflection and examination of data and the like. I also want to note for the attendees, there are questions about the PowerPoint and other resources. We will issue an email and follow-up to today's conference that includes conference resources, links to the judiciary's criminal justice information system online, which also includes the annual reports to the governor and legislature that has some more detailed data that I think is responsive to some of the continuing questions. And on that,
Lisa, you have more than one question, because I can go on, because I think here's the comparison between the old system. In the case that Nick mentioned, State versus Johnson, it is the consideration of who gets bail and the amount of bail was done in the following. Was the person employed? Did the person, what neighborhood did the person have? What character friends did the person have? What kind of housing did the person have? All of those really, I argue, external factors, which can be argued even today, but they shouldn't be the driving force as to whether a person is pretrial detained or released. So the old system, that's what we're comparing ourselves to. Nick correctly pointed out, we're not comparing a new perfect system. We're comparing a system against the old system, which allow for all those arbitrary and capricious factors to be considered, whereas your criminal history has to be the foundation for whether you're likely to appear in court or commit another offense in court. So I think it's critically important that that message go out.
Thank
Lisa,
you, Judge.
There are
Nick?
just two questions I just wanted to comment on really quickly. One was no, somebody asked if race was considered in the decision-making framework, and that the answer is no. The decision-making framework is still blind and objective based. It's just our policy of our risk tolerance level, but it does not consider any factors outside those considered by the PSA. And second, somebody commented, is there any data on how consistently indictments and pretrial hearing deadlines are met? And what I will state is that there's not data that we share with the public. However, they are reviewed on a weekly basis by the court staff so that we are ensuring that deadlines are met. And when they're coming up to a deadline, the parties are brought in to see what needs to be done to move that case.
Thank you. Thank you, Nick, and thank you, Judge Grant, for that additional information. I'm sure the attendees are finding that detail helpful. So on that note, we're going to transition to the next segment of our conference, which is a panel titled "The Practical Realities of Criminal Justice Reform in New Jersey, How CJR Shapes Justice, Equity, and Public Safety." For this portion of the program, I want to bring back to the virtual stage Judge Grant, and also introduce Director of the Division of Criminal Justice, Lindsay Rotolo, Director of Training and Communication for the Office of the Public Defender, Jennifer Saletti, and Director of Supreme Court Advocacy and Senior Supervising Attorney for ACLU New Jersey, Alex Shalom. Welcome to each of you. Thank you for joining us this morning. So we're going to go directly to this conversation and start with the question of, how does CJR promote the rule of law, ensure constitutional protections, and provide for public safety? And for this question, we'll start with Judge Grant.
There's a balancing act that takes place with regards to criminal conduct in every jurisdiction. In our state, we understand that there's a constitutional principle which we believe in, which is the presumption of innocence. There's also an understanding that certain high-risk individuals need to be detained while they wait on their trial. And what this criminal justice initiative is trying to do is to try to answer both of those critically important initiatives in a fair and balanced way. As you heard me here earlier, have you heard me state earlier, it tries to balance a defendant's prior criminal conduct and making an assessment as to whether that person should be detained. But what we also recognize is the statute creates a presumption, which is different from most other criminal reform initiatives across the country. It is a statutory presumption of pretrial release with conditions whenever possible. And balancing public safety and the presumption of the right of innocence is really what this whole initiative is about.
Thank you, Judge Grant. Director Rotolo, you're next.
Thank you so much, Lisa, and thank you for the invitation to be a part of today. It's really an honor and a pleasure to be among the other panelists and talk on this important subject. As for the question, maintaining the rule of law is only possible when the community has faith in the justice system and trust in our institutions. And while there is always more to be done to maintain and build community trust and faith in our systems of governance and justice, I feel that the New Jersey criminal justice reform was a tremendous step forward in that effort. CJR restored confidence in our justice system in many ways, but I think most significantly in the near elimination of monetary bail. And I know many other speakers in this program have already touched upon it. And I just want to kind of add to that conversation that for decades prior to this reform, New Jersey's pretrial release was based almost entirely upon a resource-based system. And the switch from resource-based to risk-based is really critical to maintaining the rule of law and faith in our systems, because the old system was neither fair nor effective. It meant that for all practical purposes, defendants were released or detained pre-trial based on whether they happened to have the financial means to post bail. And that meant that people accused of low-level offenses were being detained, and people who had the means, whether just by virtue of their financial situation or from ill-gotten criminal means had the ability to post bail were out regardless of sort of the potential violence or dangerousness that they pose to the community. It tended to inherently discriminate against the poor, and it was a system that needed reform. And the switch to risk-based not only eliminated something that was inherently unfair, but also restored public confidence in the system in that it ensured for better public safety by allowing us to consider collectively the threat that an accused person may pose either to a witness, the victim, or the community at large in making decisions collaboratively. We were able to better protect the public. And it also allowed for counsel for the defense, counsel for the state, and the court and court services to work collaboratively to fashion really individualized conditions for pretrial release, which meant that more people could be out, but in also balancing the safety of the community by ensuring that the appropriate controls and services were in place for people awaiting trial. It took us, those decisions, those conversations about the ability to be released were happening in bail bonds offices, and people, whether they accused or their families, were having those conversations sort of without the oversight and without the checks of the court system, and with competent counsel, being part of that conversation and bringing that into the light, into a public setting where we could have a conversation about and a transparent process that both the accused and the community could have confidence in was a significant improvement in the state.
Thank you. Next, we'll hear from Jennifer Saletti.
Hello, and I also want to thank everyone for inviting the Public Defender's Office to participate in this conversation, and to thank the sponsors and everyone behind the scenes that worked so hard to make this program possible. In the context of, within the context of pretrial justice reform is one of the only times that I think in my life that I've ever quoted Chief Justice Rehnquist. But he said, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. And that's from the Salerno decision. And I can't put it more succinctly than that. Our criminal legal system is based on this idea that liberty is the norm. And unless and until there is a serious need or an adjudication that requires somebody to go to jail or to go to prison, people should be free. People should be at liberty. And with CJR, for all the reasons that we've heard about so far in this program, New Jersey has at long last really embraced that idea. But I want to talk about a part of your question and something that we don't always talk about, and that's the public safety piece. We do talk about public safety, and Judge Grant talked about it earlier, and we've heard about it in other presentations, that public safety, part of public safety is people who are determined to be a flight risk or to pose a danger to the community are those that are going to be pretrial detained. But what we don't often talk about is the other side of public safety, and that's that liberty ensures public safety too. And what I mean by that is that, as Judge Grant talked about earlier, the first few days of somebody being incarcerated have the most devastating consequences to their lives. If people at home kind of think about what were to happen if they were to suddenly disappear for 3 or 4 days, you lose your job, you might lose your childcare, your family will be thrown into turmoil, you might not be able to pay your bills. And that puts people in a dangerous situation. That puts people in situations that really impact not just themselves, but their family. So I think another thing that we have done here with pretrial justice reform, when we think about public safety, it's not just those people who are detained. It is the people that are on release and now have an opportunity to continue to be employed, to continue their family ties, and to continue their community ties while they are dealing with criminal charges. And that is a huge part of public safety too. So I will pass it on. I'll pass it back to you, Lisa, to pass it on to whoever's next.
So Lisa,
Thank you.
can I follow up with Ms. Saletti's comments?
Mm-hmm.
as many of you should know, the statute, the Criminal Justice Reform Statute, says that individuals should be released within 48 hours. Our Chief Justice has made a concerted effort to get people released within 24 hours. And on average today, we're having people released probably less than 12 hours. So we talk about that liberty interest that Ms. Saletti has talked about. We have made a societal commitment to try to process those individuals charged with an offense in the quickest, most expedient fashion as possible. And that's one of the accomplishments that Ms. Saletti is talking about.
Thank you, Judge Grant. Next, we'll move to Alex Shalom.
Thanks, Lisa, and thanks to everyone for having me. I'm excited to be here. The joy, I guess, of going forth is that my excellent co-panelists have all said many of the things I would want to say. So let me just try and amplify a couple points that they made. First, to something both Judge Grant said earlier and Nick Solomon said earlier. When we think about the system that we've built here in New Jersey, which is a very good system, but not a perfect system. It's a flawed system. What we can't do is compare it to some dream we have of what a system could be. We have to compare it to where we came from. And what we came from was a deeply irrational and flawed system where the size of your wallet determined your freedom. And just to get to the point that Jen was just making, that had profound effects on people. It wasn't just that it was irrational, that's bad on its own, but jails are horrible, violent places. And I don't just mean the acts of physical violence that may or may not exist there. I mean, the act of removing someone from their family is on its own an act of violence. And so to do that is a big deal. And if we're going to do that, we have to make sure that the decision is a rational one. It's an informed one. And to do it merely because of a person's poverty is just crazy. And its effects impact that person. They impact that person's case, right? Because we know that people who are detained pre-trial are more likely to plead guilty. They're more likely to be convicted at trial. They're more likely to get a harsh sentence once convicted. All of those things impact their trial, but also impacts the person's life in the ways that Jen talked about, and their family and their community. So to the extent that our new criminal justice reform system has limited those instances, has reduced the number of people subjected to that violence, that is a good thing. And to the extent it has tried to be more rational in deciding who gets detained and who gets to live in freedom, that is also a step in the right direction.
So moving the conversation forward, what has CJR meant in terms of your respective places within the criminal legal system in New Jersey? And for this part of the conversation, we'll turn first to Director Ruotolo.
So CJR changed so much about the way in which prosecutors do our jobs, but there are two areas I really want to focus our attention on for purposes of this conversation. And one is an area that all the panelists have already touched upon, which is the public safety element. And I think Jen and Alex and Judge, you all said it perfectly in that you're absolutely right. Someone's liberty interests are just as much a part of public safety as protecting victims and witnesses in the community at large. That is then a piece of it that cannot be overlooked. In fact, it is just as important as sort of the traditional law enforcement public safety aspect of it. And that traditional law enforcement public safety aspect of it was really critical to prosecutors because we were able, because the state reallocated its resources to make pretrial detention services a priority, we were able to confidently participate in collaboratively fashioning pretrial release for people who would ordinarily be people we would be concerned about having have their freedom prior to detention. We were able to fashion really specific, individualized pretrial services and controls for people. And that made it so that only those really limited cases where the extraordinary action of taking away someone's liberty pre-conviction, pre-trial were the ones that were being detained. And that assured for the safety of our community at large, but also for the rights of the accused. And the other area of significant impact for prosecutors is one that I think is often lost in the conversation, and that is prosecutorial involvement at the charging stage. And I think that was a critical improvement. And that came from an AG directive that was issued a couple months before the law came into effect. At the time, I was a line assistant prosecutor in a county that already had that practice, but that was not statewide. And through an AG directive, it became a statewide requirement. And what this means is that for an officer to file charges, the most serious charges, indictable offenses and some disorderly persons offenses, they had to get an assistant prosecutor or a deputy attorney general on the phone in real time to approve those charges. And that did a lot to further sort of the dual responsibilities of every prosecutor, right? We have the responsibility to at once protect the rights of the accused, but also the safety of the public. And by being involved so early on, we were able to better serve those two dual goals. It meant that we could advise on probable cause determinations and ensure that there was sufficient probable cause for those charges to be filed. It meant that we could advise on investigative steps to build better cases for better prosecutions, for in the end, better public safety. It meant that we were able to consult and provide legal guidance on what the appropriate charges were and limit them to only those appropriate charges. And it meant that we were able to be involved much earlier in the process, getting discovery to our adversaries much earlier in the process, and to make smarter decisions about when detention was something that we need to move for. So that requirement, I think, was something that really impacted our ability to do our jobs.
Thank you. Jennifer Soletti, your perspective from the public defenders.
Thank you. We've been talking a lot about sort of institutional change and structural change that pretrial justice reform has brought about. But when you ask a question to a public defender about how something has impacted their practice, it always comes to kind of putting our individual clients at the center of that question. And I can tell you just personally, as a trial attorney who has stood next to many, many people who are in the positions of those people that we're talking about, one of the most painful things back in the old days, I guess the days before pretrial justice reform could be called the old days, back in the old days, was seeing a person who was in custody with so much to lose. And maybe they have an excellent case, right? They have a great motion to suppress. They have a strong likelihood of success at trial. And to be the person looking them in the eye and saying, you're going to win this motion. I think you can win this trial. Let me schedule that motion for 6 weeks from now. And then the prosecutor comes in and says, well, I'll offer you probation. And the person winds up taking a plea because they want to get out of jail, because they can't afford the $2,500 or $1,000 in bail. That was one of the most painful conversations that we had back with clients in the old days. So I think not having conversations like that, or less often, because sometimes under the new system, things like that still happen, but not having to have conversations with clients that tie their liberty or tie their interests in a case to how much money they have in their pocket, to whether they're at liberty or they have to stay in jail, has been a huge part of the way this has affected practice. Not watching people with good cases plead just to get out of jail, or standing next to someone who takes responsibility for a crime, not because it's what they've decided to do or what they really want to do with their case, but because they have no other way of getting home to their family or to their job or to their loved ones or to their community. That was painful. And it was a conversation that we as public defenders and defense attorneys had to have too many times with clients. So I think there's many ways that CJR has impacted our jobs, and I could talk forever about that. But to me, as the person on the panel who stands next to the people charged with crimes and represents them or represented them day in and day out, that is one of the more salient points, is that I don't hear the new lawyers that I train coming in with stories like that too often anymore. And as Alex says, this is not a perfect system. It sometimes still happens, but it's a much, much better system because those conversations are more of a rarity than they are routine.
Alex, your thoughts on this question?
I mean, hearing Jen explain that is really salient. Jen and I used to be colleagues. And in fact, I came to the kind of bail reform work at the ACLU because that experience was so vile, watching people who had meritorious defenses nonetheless plead guilty because it was their only way out of jail. But at the ACLU, we kind of take a more 10,000 foot view or 30,000 foot view or some higher view and really are worried about mass incarceration in our country and in our state. And the impact that criminal justice reform has had on the crisis of mass incarceration is really profound. So just a couple numbers to kind of put it into perspective. At the end of 2015, so these reforms had been passed, but they had not yet begun to be implemented, there were 8,899 people pretrial detained, meaning held on money bails that they could not make because there was no preventative detention. So 8,900 people at the end of 2015. At the end of 2019, that number was below 5,000. That was more than a 40% reduction. Now, and in fact, because of some reductions during COVID at the kind of peak of our concern about people being detained pre-trial, that number got down to almost 4,000. 4,092 people were detained on April 30th of 2020. That number has started to go up again, and we can have a conversation about how and why and what we can do to prevent that, such that at the end of 2020, there were 5,680 people detained pre-trial, but that still represents more than a 35% reduction from 2015. That's good. From the ACLU's perspective, mass incarceration is a crisis. It's a crisis that impacts people and families and communities, and any efforts we take to mitigate the harm are useful. With that said, we also came to this because we recognized that our jails were disproportionately filled with Black and brown people, and those racial disparities have persisted to the points that Nick and Judge Grant made. They haven't increased. We haven't seen greater disparities, but we still haven't solved that problem. And I think Judge Grant alluded to the fact that that's not a problem that can be solved by the judiciary alone. It will require work from law enforcement and prosecutors and judges. But just because one entity can't solve it alone doesn't mean that any entity can say, okay, I have no role and responsibility. And we need to continue to think of ways to try and drive that disparity down, because it's deeply troubling and it's a deep flaw in our system.
Thank you. Judge Grant, your thoughts from the perspective of the courts, what the impact has been?
The impact, as the speakers have indicated, has really been tremendous. But I would think about the following thing. New Jersey has this extraordinary foundation for systemic change. Ms. Saletti's office, led by Public Defender Kokora, Mr. Salone as a representative of ACLU, the previous attorney generals and criminal division leaders in the attorney general's office have all led to this kind of conversation, systemic conversations about how you reform systems in our state that I would argue very few places across the country can do. This kind of collaborative work, as most recently reflected in the conversation on jury selection reform, is really one of the testaments to New Jersey's system of government. And so to me, one of the real lasting changes and important elements of this program, yes, we've got new pretrial service units. Yes, we've got people being monitored. We've got people being released, and we're doing all those things. It's really a growing recognition by all segments of the system, if you will, as to how we must continually advance and improve, not just criminal justice. We're doing the same thing in civil justice with landlord-tenant reforms and other things. That really, to me, is one of the biggest legacies of this kind of collaboration. And I have one final example. We are currently involved in a criminal justice initiative related to mental health reform. We're starting 2 pilot programs. One is in Essex County, where an individual who is sent to the county jail will have a mental health navigator assist that individual if they want to, assist that individual in getting mental health services immediately upon release from the county jail. And Essex is our biggest population center in terms of criminal defendants being detained in our county. We are working with the Center for Court Innovations to develop that program. We're doing a comparable program in Morris, Sussex, that are rolling out as we speak. And then I think that partnership, that collaboration with the Essex County Prosecutor's Office, with the courts, with the county jail, with the Public Defender's Office, has all been made possible by the success of this criminal justice reform initiative.
Thank you, Judge Grant. So criminal justice reform took effect January 1st, 2017. The system was in the process of the ongoing implementation. And then in March 2020, COVID-19 hit. The next question is, how have the necessary adjustments to operations due to the pandemic affected the ongoing and sustained implementation of criminal justice reform? And for that, I'll turn first to Jennifer Saletti.
So I think if pretrial justice reform kind of forced us to take a really hard look at our pretrial population and ask whether every single person in it needed to be in custody or there was a way to release them and protect public safety. And we answered that question, no, that we could do better and devised a system to allow for pretrial release. And I think if CJR was the thing that sort of forced us to look at these issues, that COVID forced us to stare even deeper to that abyss, right? To say, now, 2 years later, even though we have decreased this population, now with the threat of a global pandemic, where people could now risk spending longer times incarcerated because trials are being delayed, and people, they're literally their health, their lives are at stake, could be at stake from being in custody. Can we do even better? And the answer to that question was yes. We kind of think of this in terms of black and white, right? Like in terms of like harsher terms that, there are a certain group of people that should be released and there's a certain group of people that should be held in custody pre-trial. But there are these people, as I know Alex likes to say, on the margins, right? Folks that maybe judges would look at and see a judgment call and it would go either way. And I think one of the things that the pandemic showed us is that we can be really creative and we can structure ways to take some of these folks that may have been on the margins in terms of risk assessment score and keep the public safe and yet keep these folks in the community. So COVID, I'm not suggesting in any way that COVID was a good thing, but I think it was a good test of the system and say, can we go even further? Can we go even deeper into this problem and devise new ways to keep people out? But of course, whenever you're taking a good hard look at something under threat of a greater harm, right? Under threat of a pandemic, you might make different judgments. And I think the true test of this system, right? Like there's some expression about, when people aren't looking or when there's no pressure, that's when we know what we're made of. I think I might be making up that expression, but something along those lines. I hope that this conversation continues. And I hope that we keep that frame of mind, that our frame of mind is always, how can we release this person to the community rather than defaulting on, well, we might as well lock them up, right? What harm is it going to do? There is always a harm when someone is locked up, and we need to continue pushing forward in ways to be creative and maintain public safety, whether there's a pandemic or whether there is not a pandemic hanging over our heads.
Alex Shalom, your thoughts?
I echo what Jen said about something we can do, which is consider at the outset whether a person should be detained. But just to add a totally different point, when we agreed that there would be some group of people who would be detained pre-trial because they posed unique dangers, we also agreed that it would happen within a particular amount of time. That's the statutory speedy trial framework that Nick was talking about earlier. we now have many fewer trials. That is simply going to be a reality. It is going to be our new reality that trials will be harder to get off of the ground. And if we used to have 12 trials going on in Essex County on any given day, we'll be lucky if we have 3 or 4. And so the amount of time people are going to be in is going to be longer. And so, like Jen said, it's going to force us to look under the hood and see if there are things that can be improved. And so Nick said he couldn't get into all the excludable time pieces, and I agree, that's a many hours presentation. But let me tell you one that we were troubled by in 2015 or 16 when the court adopted the rule, and I think it's really revealing its ugly head right now, which is we have essentially 3 pieces to the speedy trial framework. There's 90 days to get indicted, subject to exclusions, then 180 days to get tried, subject to exclusions. And then there's supposed to be this backstop of 2 years that would only get extended based on delays attributable to the defendant. And so what we kind of assumed that would mean was, look, if on day 730, when the trial is supposed to happen, the 2-year mark, the defendant says, I'm not leaving the jail today, I'm not going to court, we wouldn't say, well, okay, I guess you got to get released because you didn't get your trial, because that would be a delay attributable to the defendant. But the court also included as a delay attributable to the defendant any motion that the defendant files. And that puts lawyers in a really bizarre catch-22. They're constitutionally obligated to file required motions, a motion to suppress an identification, a motion, whatever the motion may be. These are constitutional obligations. And if the lawyer abides by all required time limits, isn't dilatory at all, that is still time held against the defendant, extending this 2-year mark. And now that is coming home to roost. And you see people who are in jail for really extended periods of time. And obviously, the pandemic was an exceptional circumstance, but I think we need to adapt to that and recognize that when we agree that there might be someone for whom pretrial detention is appropriate, we are not condemning that innocent person to be in jail for 3-4 years, because that's not pretrial detention, that's detention without trial. And in our democratic system, we should reject out of hand people being detained for periods of time that are that long. So I think we need to recalibrate some of the speedy trial things as we move forward in the new reality of fewer trials.
Judge Grant, your thoughts in terms of the impact from the perspective of the courts?
The idea of not appreciating the extraordinary pandemic, health crisis that confronted our state, our country, the world, has to be considered in this time frame. I love my wife. She happens to be a judge, and for 18 months, I was seeing her almost every day, and that got to be kind of tiresome, 24/7. There is I think, a commitment by our Supreme Court that says we want these cases processed as fairly, as effectively as possible. We want them to be done in a constitutional format, which you heard Mr. Shalom talk about, is going to be less because of 6 feet of social distancing, mask wearing, and those sorts of things. The pending caseload is substantial, and we are trying to address that in the best manner we can. There is no magic bullet here. If defense counsel or others would want to file an application to get a particular defendant released, that application can be made. But the system as designed has overlaid this extraordinary world catastrophic event, which makes things possible or not possible to be done. And I think that recognition has to be understood and challenged. And I have one final piece. New Jersey, for all of its great infrastructure, has struggled with getting judicial appointments done in a timely manner. Today, we're probably at 64 vacancies. By the end of the month, we'll probably be at 71 vacancies. We should probably be at 20 vacancies to have an effective system working. So there are these external factors. One is a public health emergency, which no one could have predicted. Another one is a reasonable prediction, which is to allow for and require the judicial workforce, to be staffed at a level to handle those cases. Mr. Shalom talked about Essex being able to do 3 or 4 trials. We used to have 17, criminal judges assigned to the division. We don't have that number now. It's probably 6 or 7. That represents an impact on our ability to process trials as well. So there's no easy solution. We will do the same thing that we've always done, which is to engage in a collaboration with the Attorney General, the Public Defender's Office, and other stakeholders to say, what are the additional things that we can do to try to advance these cases more expeditiously?
Thank you. We'll turn for the final comment on this question to Director Ruotolo.
Thanks very much. And I want to go back to something that you said, Judge Grant, and that was that we are uniquely situated here in New Jersey with this foundation for that gives sort of a foundation to be able to make change and to be able to not just make reform and change, but to be able to pivot together when faced with sort of extraordinary challenges, such as what we saw with COVID-19. And there were many things to be grateful for as we saw so much suffering. But one of the things that I was grateful for was to be a part of the judicial system, the justice system here in New Jersey, as opposed to other areas of the country. Because what I saw from my perspective in prosecution was that we came together yet again, the judiciary working together with the public defender's office, other key stakeholders, such as the ACLU and other important groups, and the prosecutors and law enforcement came together to think about how we're going to face these new challenges. And we pivoted. The judiciary started the pilot program for virtual grand jury so that backlog of cases could start to be addressed before we were even able to safely gather in person. And there was criticism, there was skepticism, there were questions about it all along, but we did it and it proved to be successful, and we were able to clear, not all of the cases, but a significant number of them as we waited to be able to gather in person. And now we're back to live grand jury 5 days a week at the state. It also, one of the things that I was really moved by was the fact that our local judiciary, our local public defender's office, and our local county prosecutor's office, because at the time I was still in the county, we dropped everything to be able to look under the hood, as you said, Jen, and really focus on every individual who was incarcerated, whether it was pretrial or whether it was in the county jail serving a sentence or in state prison. We went back and we looked at every single one. And I know this because at the time I was homesick with COVID, going through 40 cases over the weekend myself as the prosecutor, because it was it was about the humanity. It was about the idea that people were in a condition that posed tremendous risk. Jail is never a pleasant environment, as Alex said before, by any stretch, but was particularly unsafe for the guards and for the inmates alike. I can not only imagine the stress it put on the family members and the loved ones of those who are incarcerated. And we took that very seriously at every level. And I think we worked really hard to try to limit who was in that position. And we did that collaboratively and collectively. And I think that's because of the foundation we have here in this state with centralized judiciary, centralized prosecution, and centralized PD, and very active stakeholders and defense bar. So a credit to New Jersey on that one.
Thank you. Before we move to the final planned question for the panelists, I'd like to take a moment to incorporate some of the questions and areas of interest that the audience is presenting. So I'm going to present this first question to Judge Grant. It's actually a two-pronged question, but you answered the second part about the disparate effect of the war on drugs that have impacted communities of color. So I'll present the first part, which is, are judges required to attend implicit bias classes or training? Are they encouraged to look at prior incarcerations as a systemic racism issue?
So the first part of your question is, every lawyer, including judges, by a mandate of the Supreme Court, is required to take implicit bias training as part of what we call a continuing legal education. But what the judiciary does is every year we bring all of our judges, whether they're municipal or state, and we provide implicit bias, discriminatory conduct training. Ms. Burke, you've been one of the principal presenters of those programs. So that's something that's built into the organization. But what the Supreme Court also did recently was to say that all 9,000 plus members of our organization from the administrative side have an equal obligation to take implicit bias training as well. There was a question earlier about restorative justice. And I would argue that drug court, which now will likely be called recovery court, is probably one of the best examples of restorative justice in our system. You are allowing people who have been subject to the horrors of substance abuse now to undergo treatment, to reclaim their lives, if you will, and to get that record expunged if they go through the program. That similar restorative justice process is involved in what we are talking about in terms of this mass marijuana expungement program. And later on in the day, you're going to hear a conversation by Mr. Hart, Maurice Hart of our probation department, who will talk about a jobs initiative where the judiciary is working with both large and small businesses to try to get those individuals job opportunities. And what Judge Sampson, who is the co-chair of the program, or vice chair of the program with me, what he talks about is a living wage job, a job that pays benefits. And we are working with New Jersey Transit, Robert Wood Johnson, Cooper Hospital, literally every big and small organization in the state. And many of them have stepped forward and says, yes, I can use the Amazons of the world, the Audibles of the world, Wake Firm and others are all saying, we are willing to partner with the judiciary to give these individuals a job opportunity. So restorative justice is one part of that spectrum of this great state. Like, it's not always singly respective, as I said, of just the judiciary. It's a collaboration, including many, many partners, trying to help citizens get a second chance to improve their lives.
Thank you, Judge Grant. Would any of the other panelists like to comment briefly on the potential for expanded restorative justice in New Jersey?
I'll just say, I think for restorative justice, we should have a broad view of where we can go. I think there have been some really fascinating and thought-provoking, there's been some fascinating and thought-provoking research around the use of restorative justice for serious violent crime and the ways in which it makes us safer and provides more peace of mind to victims and holds people who cause harm more accountable. And so I would commend, and look, the judiciary has, as Judge Grant said, been at the forefront of these conversations among judiciaries. And so I think we've done great work, but there's more work to be done, and we shouldn't, it's easy, frankly, to say that we should expunge marijuana convictions. Marijuana is not illegal anymore. And every, sitting US president for the last 30 or so years has used marijuana. So that's hardly groundbreaking at this point. But I do think we can set the bar really high for pilot programs around restorative justice, even for serious violent crime. The book that I would recommend to everyone is Until We Reckon, by Danielle Sarid. Is that her name, Jen? Yeah. It's really an amazing book, and the program she set up largely in Brooklyn and around the tri-state area has been really impressive in getting results. And so I think there's more to be done, but I think we're poised to do it for all the reasons Lindsay set forth earlier.
And I had just one other restorative justice program, which sort of answers or is in response to Mrs. Shalom's statement. We're currently involved in a statewide initiative to what I call a gun violence initiative. That is, individuals who have been convicted of guns or weapons offense are now engaged in a community collaboration. It includes members of the community, as well as judiciary, as well as law enforcement, on trying to partner with those individuals' services that are community-based. So we started the project in Patterson, given the high gun violence up in that community. And every week, a group of citizens from Patterson, from Passaic County, along with Judge Capicella and others, are involved in assisting Glenn Grant, the defendant, Glenn Grant, a felon who has been convicted of a weapons offense. What are the services that you need? Do you need housing? Do you need employment? And that initiative is being rolled out in all 21 of our states. So it may not be exactly what your office is talking about, but it's an idea of saying these people who have committed significant offense. We have people from St. Joe's Hospital talking about the horrible consequences of weapons of violence to this very young population as another tool. New Jersey judiciary is not going to stop in doing these initiatives because we believe that the work never ends. But it does say that we can deal with that, what I would consider a tough population, to try to provide them opportunities to remain law-abiding and members of our communities.
There's just one small point I wanted to add to this, because I echo everything that Alex and Judge Grant just said. But I think one thing that is really important, well, I'm going to say two things that are really important, is that this happens at every part of the process, right? It happens at pretrial. It happens while you're negotiating the outcome of a case. It happens even at sentencing and is considered in sentencing outcomes. That restorative justice has entry points at every part of the case. It can be a part of any stage of the case. It can even be parts of application for release. The other thing that I think is very important to remember is that the importance of the voice of people who are incarcerated and formerly incarcerated in these conversations. And I think too many times when we're having these discussions as a community, the folks that we leave out are the people who have been impacted or are the most impacted. And I see this at the conferences that we have. I'm not talking about this conference necessarily, but I see this at a lot of conferences that we have, and even discussion groups and boards and advisory boards that are put together. There are so many organizations out there that have been created by the formerly incarcerated. We saw groups like that who were partially responsible for restoring voting rights and are working on some of the other important reforms to prisons and the criminal justice system. So I wanted to kind of at least try to amplify those voices and hope that they are always considered as part of the conversations moving forward, because they're really important and really insightful into the decision-making of all the stakeholders.
Thank you very much. There are a few other questions, but I'll just provide information regarding. So there's a couple of questions about family part matters. We certainly can provide information on informational sessions that the judiciary hosts, community conversations, which includes an opportunity to raise questions about those operations. There was a question about the driver in Wisconsin who killed people at the Christmas parade. I guess media reports use the phrase was too easily released on bail. So the question is whether Wisconsin system is different or similar to New Jersey. So I think it's safe to say, just as a general point of information, it's a very different bail system. And then if there are any other questions that are case specific, we certainly can connect people to the appropriate ombudsman in the vicinages. So on that note, we're going to turn to the panelists for the last question of the session. And starting with Alex Shalom, what do you see as the biggest improvement resulting from New Jersey's CJR effort and the current criminal legal system in New Jersey?
So I've already kind of talked about the substantive one, which is there are thousands fewer people incarcerated with, obviously huge ripple effects for, right? That's thousands of kids whose parents are home and thousands of communities that don't lose a breadwinner. And all of those impacts are huge, and I think at the forefront. Let me say something about the process piece, because I think it's been truly remarkable in New Jersey, which is when we walked into the Joint Committee on Criminal Justice first meeting, there were prosecutors, there was the Attorney General, there was the person who has Lindsay's current job, there were the public defender, Jen's boss was there, and these were folks who didn't tend to get together other than when they were in courtrooms on the opposite sides of the aisle. And they came together for a common purpose, which was recognizing that the system we had was failing. It was failing as a matter of fairness. It was failing as a matter of public safety. And everyone made concessions that led us to a better system. And that has been a remarkable model. And so when Lindsay talks, and I'm sorry, Lindsay, that you were sick in March when that first consent order came around, but that was another instance of these same entities collaborating to a common purpose, to get people out of jail who could be safely gotten out of jail as the pandemic was starting to sweep through New Jersey. That wouldn't have happened if there hadn't been a trust built up over time between all the stakeholders who were involved in this criminal justice reform effort. And so I hate to use my last word to compliment prosecutors, but I'm going to have to do it. Because I think it really, the collaborative effort of prosecutors, the judiciary, and what I'll call the kind of defense side stakeholders, the OPD and the ACLU, has gone a long way to improving the lives of many New Jerseyans and getting a lot of New Jerseyans out of jail and even sometimes prison. And that is a remarkable and important thing. Since I don't want to actually end on that note, it's just too antithetical to who I am. Let me just answer, Lisa, the point you said about Wisconsin and that horrible tragedy there. Not only is the New Jersey system dramatically different than the Wisconsin one, but the media reports blaming bail reform, which incidentally, there hadn't been bail reform in Wisconsin in over a decade, blaming bail reform for the horrible tragedy there are totally scare tactics, misguided, and not grounded in reality. Now, that doesn't mean that that gentleman should have been released on whatever bail he was released on. I don't know enough to say it, but I do know enough to say that Judge Grant was spot on when he said, we can't have a system that's going to get it right every time. And what we have to try and do is measure risk and manage risk. And the only way we could ensure that no one ever committed a crime while on pretrial release was to not release anyone. And that, to Jen's earlier point, would have devastating effects. And so I think just a kind of PSA for everyone out there, whenever you hear people blaming bail reform on things, look below the surface and see what's up. And I think in the Wisconsin case, we can say that it is absolutely untrue.
Yeah. Director Rotolo.
Thanks. And Alex, I appreciate it, but I always appreciate the work of your organization. You know, I think we've touched upon some of the biggest improvements here, the public safety and the collective focus on individual liberty.
Yeah.
Oh, sorry.
Yeah, I'll go back.
Okay. The near elimination of cash bail in New Jersey, and then if I could just talk about two process things as well that I see as really tremendous improvements. And that is one, just as a practical matter, this new system has put the defense attorney, whether it be public defender or private counsel, and the prosecutor responsible for the case in a room together much earlier in the process. And in my view and in my experience, that has led to quicker resolution and better resolution. And sometimes the services that are provided pre-trial that allow for safe release of an individual have, when I was practicing, have changed my view of what the appropriate outcome would be. And sometimes a case that started as, you know, my thinking was in the end, this should be a custodial term, changed because of the success somebody had pre-trial, so that we were able to fashion a probationary resolution at the end. And I think that's a credit to sort of the relationship and the collaboration between counsel in this state that I think is really rare and really special. And the last note I would make on process is that CJR, criminal justice reform in this state, was, we have to credit Judge Grant, yourself, and Chief Justice for your leadership on this. But I think you also deserve tremendous credit for the acknowledgement that it's not perfect and that we have to constantly come back together and re-examine where we can improve it. And I think today's event is one of those moments. The tremendous conference that was put on a couple weeks ago is a continuation of the foundation that you built with CJR. And bringing all of these folks together to work collaboratively. We're continuing to reassess, and you did it in May of 2017 after the initial risk assessment and was put out. We went back and revisited it where we thought it could use improvements, and the court took the lead on that and changed it so that gun offenses and recidivism on release were better accounted for. And that was something that really improved public safety. And we continue to do it step by step. And one of the things that came up during the COVID pandemic and the collaboration on that front was a recognition that we can do more in terms of services for people who are released. I thought the PD's office did a tremendous job in marshaling the limited resources that we had at the time because of so many things being shut down during COVID, to really make sure that people who were released because of our collective efforts were getting what they needed to be successful while out in the community and to be safe while out in the community. And I don't just mean in terms of like community safety, but individual safety at a time when housing insecurity, food insecurity, job insecurity were on the rise. I thought the PD's office and court services did an amazing job on that front. And it highlighted the need for continued work in the area of reentry services. So I think the biggest improvement is not just what was built, but what the foundation that you laid for continued improvements.
Jennifer Soletti, your thoughts on the biggest improvement?
So in thinking about answering this question, I was actually thinking about our conversation about restorative justice and participatory justice, because I think one of the things that this new system has done, beyond all of the other things that we've talked about, is it's shown us the importance of intervening and giving our clients or giving people accused of crimes services upfront rather than later in a case. One of the pretrial services does have access to be able to give people accused of crimes and out on terms of pretrial release some services. I think this is an area where we need to push forward, where we can do more. Because the more services we give people up front, the more opportunity we give people up front, the better outcomes we were going to have in the back end. And Alex, you just ended your comments by saying you were going to compliment prosecutors, and I also, join in the compliments of prosecutors and the judiciary and all of the stakeholders that participated in this process and are participating in the other major reforms we're undertaking. But I'm going to do you one better, because I'm going to read a comment from a prosecutor, because I think it actually says more eloquently what I wanted to say. And it's from Jennifer Webb-McCrae, who's been both a public defender and a prosecutor. And it says, it's great to talk about restorative justice solutions. However, to be truly transformational, we need to also be reallocating resources to front-end systems, mental health, substance abuse, child welfare, social service that historically fail Black and Brown and poor people, who are then pushed to the criminal justice system and then hold those systems accountable to serve their needs. Let's work on the front end and back end simultaneously to effect true change. Otherwise, I fear we'll be in the same position 20 years from now. And I can't help but agree. There is a trend in this country to move towards more holistic defense and moves towards holistic partnership to give people all of the services that they need to be successful. And that success doesn't mean to just successfully navigate their case, but it means to never come back into the system. Pretrial justice reform is a tremendous start. Pretrial services has done a tremendous job with the resources they have. I hope we can get them more. I hope that we can continue to work together in having these conversations and bringing about these changes, because New Jersey truly is a special place where we can get a lot of these things done when the stakeholders work together. And again, put clients at the center, put the accused at the center of this, with goals in helping them succeed, making communities safer, and ensuring people don't come back into the system.
And for the final word, both on this question and this panel segment, return to Judge Grant.
Panelists, I know all of them. They are really two champions in not only criminal justice reform, but just lawyers in our system. And I thank them for their great work and many, many years of dedication to the legal profession. When I think about the significant improvement or change, I always look at it from a societal perspective. Courts are not a single institute. They exist to serve the larger public. We represent the best opportunity for modernity to take place through an organized way of resolving disputes. But what I would also say is this criminal justice reform initiative is not written in stone. There is always an uncertainty when you are trying to move that arc of Dr. King. At the jury selection conference that we held a few weeks ago, Professor Eddie Galoud gave some keynote remarks. He was absolutely wonderful. And one of the things that he wanted to make certain we understood is, anytime that pendulum is swinging towards one direction, in this particular case, and towards a progressive direction, there is an opposite push. And so without the advocacy and the commitment of all of you in this room and others, we will be where Prosecutor Webb McCrae is. We will be here back talking 20 years from now about what happened to the Criminal Justice Reform Initiative. It takes hard work, it takes dedication to build long-lasting roots and to build a lasting tree of reform and success. So for me, I want to just thank everybody for this collaboration, for this commitment to reform. We are involved in it on multiple efforts. I could spend hours talking about all of the things that we're partnering with communities and others. But it represents, to me, the importance of this work. Cornel West says, justice is what love looks like in the public space. And that's really what we're talking about. What does justice look like for all of us? And that's a balancing between public safety and the Salerno opinion, which says the defendant's right to liberty is to be the norm. So we're going to stand with you. We're going to be working more to try to advance the important work of this judicial system at every single level of our system. Again, thank you all for participating.
Thank you, Judge Grant. Thank you, Director Rotolo. Thank you, Jennifer Saletti. Thank you, Alex Shalom. This truly has been an informative and engaging session. Our program is not quite over yet. We have a lightning round with 3 speakers who are going to provide brief overviews with regard to municipal court reforms, probation services reforms, and the expansion of access to expungement. So first, I turn to Steve Summitt.
Lisa, thank you very much. My appreciation to the council for allowing me a few minutes this morning to speak with you. I know you got a busy agenda, but I want to touch on some of the real significant things we've done over the last couple of years for municipal. Again, I'm Steve Summitt, and I'm the Assistant Director of Municipal Court Services. In my office, under the direction of Judge Grant, we oversee all the municipal courts in New Jersey. There were 2 primary drivers that really force us to do things differently over the last few years. One is simple, and everybody had to make a change. This was COVID. It forced us to really rethink what our normal was and what our normal would need to be. It forced us to look outside the box and to really consider new possibilities. The second driver was a series of reports that the Supreme Court had initiated. The first was a 2018 report that was the Supreme Court Committee on Municipal Court Operation Fines and Fees. There was a secondary report that came out the following year from a committee chaired by Judge Grant. Both reports yielded in total about 70 different recommendations. And the real goal behind both reports was to really focus on our municipal court practices and identify ways that we are doing things that can disadvantage defendants of lesser means. In short, the Supreme Court really challenged us and directed us to look at what we do and identify how we can do better and how we can be better. I'm going to touch on just a few examples of what we did because I know our time is short. The first is simple, and I don't need to have a huge explanation about it, but we've done what all the other divisions have done. We've moved towards a virtual format. In January of 2020, we probably only had a handful of municipal courts that really utilize video conferencing. Now, all of our municipal courts, since June of 2020, the municipal courts have scheduled about 4 million matters virtually, involving about 2 million different defendants. Now, that's pretty significant when you consider where we were just a few months prior to that, where our courts didn't have the equipment and needed to really get up and running. That was really through the leadership and the vision of Chief Justice Rabner, Judge Grant, our vicinage leadership, and of course, what I consider the Herculean efforts of our municipal court judges and administrators. Important to note, and it's probably the most common question I'm asked when I talk to my municipal judges and court administrators is, well, where are we going? What's the future of municipal? Recently, the Supreme Court just issued an order talking about the future of the judiciary, and in that is some real key information about municipal courts. In short, virtual is here to stay. It will be a major staple, in fact, really the primary staple that we will want to resolve matters for the defendants who need to appear in court. Very serious matters such as DWI and some of the and matters where there's really complex issues going on, complex discovery, and some other challenges will be heard in person. But I think it's important to note that long gone are the days of packing 100 people into a tiny courtroom. That's a culture change, and we're going to continue pushing that from my office and working with the vicinages and all the courts on maintaining that. Probably one of the most exciting programs we've done over the last year or so is what we call our municipal case resolution system. In short, and is now operational statewide, it allows a defendant through our NGMC direct process, our online application, to reach out to a municipal prosecutor to initiate a possible plea deal. The defendant sends something through our system. It goes into a work basket that the prosecutor has access to, and the prosecutor will look at the case and make a determination on whether to offer a plea deal. That's all electronically, and it goes back and forth through the system. If approved by the judge, the defendant need not show up for court. And that's a common theme that I wanted to mention earlier. All the initiatives we've really done over the last year, so many of them have really been focused and predicated on finding ways to make it easier for defendants to resolve their matters without having to come to court. In other words, how can we really bring our municipal courts out of the 1980s and into the 20th century, where we're leveraging our technology and leveraging our better know-how to really make our courts still, the pillars of justice they need to be, but also understand where we are today as a society and how we needed to grow and move in good directions. To date, 10,000, tens of thousands of folks have used that system to initiate or reach out to the municipal prosecutor, and we anticipate that continuing to grow in the future years. Another significant change made by the Supreme Court in March of 2020, and this was literally weeks after the pandemic really hit us, is a major change to what we call our plea by mail process. Previously, municipal court, in order to do a plea by mail, in order for a defendant to use a form to initiate their plea and provide their information to the court as a way for them not having to appear in court, the defendant had to prove a hardship. The defendant had to live in California. The defendant had to be away at college somewhere. The defendant had to, just major challenges for them to get to court. Supreme Court relaxed that hardship, which really opened up the doors for, I would say, any defendant, because there were still some exclusions, defendants who have a potential jail term, defendants who have potential loss of license, et cetera, will still need to appear in person or virtually. But this just allowed a much greater degree of flexibility for most defendants, which is where we were going anyway. But COVID sort of forced our hand a little bit faster than I think we were anticipating. But that was a good thing. Importantly, we're working now on an electronic application for our plea by mail. In other words, it's going to be a plea online application that anything somebody can do on the paper form. We're going to build the same type of application that we have for our municipal case resolution and allow a defendant to initiate that outreach to the court electronically through our system. Speaking of our systems, earlier this summer, we launched what we call our Municipal E-Courts Initiative. What this is, coming in line with what the Superior Court does in so many ways. We've developed an online application that allows defendants, attorneys, really almost anyone to reach out to the municipal court electronically through our system. Attorney can send a letter of representation, and defendants can send in queries about their case or about anything. Parties can submit adjournment requests. Motions can be filed. Some of the changes we're looking to make in the coming months will be allowing a defendant to electronically enter a not guilty plea through that system, or to allow a defendant to electronically seek the services of a municipal public defender, as opposed to having to wait for he or she to be in court to be before a judge. They can do it electronically, and that information is with the court prior to the court hearing. Probably one of the most significant changes we've made also involves what I call our TPay process, which is our time payment process. Earlier this year, Judge Grant issued a directive number 1221, that totally flipped our process for enabling defendants to pay in installments. In other words, if a defendant owes $200 based on having a couple tickets, and that's their financial obligations, most defendants, or at least a pretty high number of defendants in many courts, don't have the ability to pay that money all at once. What the new protocol does is it really enables almost any defendant to be able to get a very, very reasonable time payment application. Previously, the policy really almost required a defendant to be indigent. What we've done is we've really removed the indigency context and placed the emphasis on really almost any defendant is, hey, let's find a good, easy, flexible way for people to resolve their matters. And we've really directed the judges to work with defendants to make sure that if there is a payment plan, that it is reasonable, because we obviously don't want to set folks up for failure. 2 additional changes, and I'm sorry, Lisa, I'll try to be really brief on this, but I think they're critically important, and I think they're things that the council would be very interested in. They're not tied to really enabling defendants to come to court easier, but they have a huge impact on some of the conversations that we had earlier about restorative justice. The first is municipal court dismissals. In January of 2019, the Supreme Court issued an order that dismissed nearly 800,000 old, minor, outstanding. In other words, these were cases that had not been resolved in court, dismissed nearly 800,000 of those cases. All of those cases were at least 15 years old. Many were 30 years old. In other words, they were just on the books, and there was, there were warrants that had been issued or license suspension or something. And after 20 years, the court decided, hey, it's time. Let's do the right thing. So as an offshoot of that, and this was one of the recommendations that stemmed from the Operation Fines and Fees report I mentioned earlier, a new court rule change has been put into place, which requires now a regularized process for the courts to review and dismiss old, minor, outstanding matters. And it's important to say, when I talk about minor, there are some of the more serious municipal cases are not included. We're not including DWI. We're not including disorderly persons offenses. We're not including some of the more real serious traffic matters, such as DWI, such as driving while suspended, driving without insurance, that have real safety issues. These are more run of the mill. Somebody did a turn on red, they got a tail light out, etc. Earlier this year, the first iteration of that dismissal program went into effect, and the Supreme Court dismissed approximately 300,000 matters. Over the next year to 15 months, we anticipate upwards to an additional, it'll be the court's decision, obviously, but we would anticipate upwards to an additional that are at least 10 years or older. The goal is to help folks move forward with their lives, and from the court's perspective, obviously clean up some things that we really should be focusing on. I think the second thing I want to touch on real briefly is something that happened January 1st of this year. Based on legislation, NJSA 2B:12-31 was repealed. That is the statute that authorized municipal court judges to issue license suspensions if somebody failed to appear or failed to pay. So as of January of this past year, legally, municipal courts will no longer, except for parking was excluded from it, but these are all ordinance violations, DP offenses, regular traffic matters, etc. If a defendant fails to appear or fails to pay on any of those matters, the court will not be issuing a license suspension. So that's about it for me, Lisa. I hope that provides some good information for folks.
Thank you so much. The municipal courts clearly are many people's first, if not only, point of contact with our court system. So knowing about the many advances and access to the courts at the municipal level is so important. So thank you again.
Thank you, Lisa.
Next, Probation Services Ombudsman, Maurice Hart.
Good afternoon, everyone. I'm Maurice Hart. I am the Ombudsman for the Office of Probation Services. And I just want to touch on a few reforms that has taken place in probation. But first, I'd like to say that Probation Services is committed to the welfare and safety of children, family, and communities through the fair treatment of all individuals by promoting positive changes in behavior through the use of evidence-based practices, ensuring that individuals remain accountable to their families and the community, and by working with our community and stakeholders while responding proactively to the changes that we are seeing. Public safety is critical to the work that we do. And a good example of, I'll give you an example of some of the things that probation officers actually do. Probation officers help clients to avoid further criminal activity. They help them to change their lives for the better, and they help them to become productive members of the community. They also aim to ensure that clients pay their court-ordered payments, fines, reimbursement, and child support obligations. Probation supervision involves requirements such as reporting to a probation officer, attending school, work, or job training programs when appropriate, participate in substance abuse and other treatment programs, as well as perform community services, community service hours. We aim to engage, connect communities, families, and resources in the community. We apply individualized and developmentally appropriate interventions such as sanctions and incentives and treatment services. And all of this is based on the client's risk and needs. And we do this to promote positive behavior changes. We aim not to intervene when intervention is not necessary. And we use our decision-making tools fairly and equitably. Our engagement with our clients is driven by the best practices on what research says works. Probation helps clients achieve long-term abilities to stop and/or reduce criminal behavior. And we do this through facilitating positive behavior change. And so the goal of public safety for us at probation is best met when the interventions and practices that we apply succeed in helping clients change their lives for the better. A good example of this is the Judiciary Opportunities for Building Success program that Judge Grant briefly spoke about. In 2018, the Chief Justice asked Judge Grant to assemble a committee that would address employment and training needs for probation clients. These clients, the targeted clients, are clients who were in need of job readiness and employment and other training in order to obtain meaningful jobs. The committee is now chaired by Judge Grant, and the vice chair is the retired Superior Court Judge, Mark Sanson. The jobs program or the committee is designed to connect probation clients to employment opportunities, job readiness program, and skill building opportunities. This program presents an exceptional opportunity for us to strengthen the collaboration between government entities and the business community while providing individuals with a chance to reclaim their lives. Members of our committee, the Jobs Committee, include business and corporate leaders, community college and other educational institution representatives. The New Jersey legislature is on board. There's nonprofit organizations, healthcare organizations, judges and staff from the businesses and from the administrative office of the courts. Representation is present from the Attorney General's office and also from the Office of the Public Defender. Now, so far we have partnered with companies such as Amazon, Audible, Jingoli, Wayfair, Wakefern, New Jersey Transit, Goya, the Community Food Bank of New Jersey, Traffic Plan, Robert Wood Johnson, Cooper, and others. You know, I can go on and on, but all of these companies have pretty much committed to giving our clients a chance at a meaningful job. So this initiative that we have, we call it the Jobs Program. It furthers common goals of meeting and sustaining social responsibilities to the communities we serve. Many of the companies that are on board with us have a commitment to supporting our communities that align with goals such as improving the quality, safety, and well-being of the community, empowering people to become gainful members of the community, providing sustainable, meaningful employment opportunities. And when we talk about meaningful employment, we're talking about jobs with benefits, jobs that have health care, jobs that are not temporary jobs. You know, these jobs can really change the trajectory of some of our clients and their families' lives. Other goals are helping clients to help themselves, providing our clients with a fresh start or second chance, if you will, and also stopping the cycle of incarceration. The other thing I'd like to add is that it also helps us to increase the number of tax-paying members in our community. So the Jobs Program is an important step in helping probation clients we serve build a foundation for their future success. and becoming gainful members of the community. This initiative provides a platform for public, private, government organizations to help strengthen and support the communities. Through our partnerships, we can solve problems to meet business and government needs. So that's a brief description of our JOBS program, which is intended to improve the lives of our clients and improve the safety and the safety of our communities. Now, I just want to talk a little bit about evidence-based practices and the implementation of those practices in probation. So in recent years, probation's focus and strategy has shifted from a heavy concentration on enforcement and monitoring to an emphasis on rehabilitation through the use of evidence-based practices to improve outcomes for our clients, for effective case supervision, and for a reduction in the recidivism rates, ultimately creating space for changes in behavior that led to involvement in the criminal justice system. Probation has embraced the risk needs responsivity model, which identifies the needs of clients and provides targeted services and treatment strategies that focus on an individual's specific behavioral issues. We take on this approach through the utilization of a validated risk needs assessment tool. We call that an RNA. This tool helps us to determine the appropriate level of supervision required based on the client's risk. And again, when we talk about risk, we're talking about risk of re-involvement in criminal activity and behaviors. And I also want to touch on child support, which is also a part of probation services. Within our child support enforcement unit, we are also being more proactive about assisting obligors break down barriers that they may encounter in complying with child and spousal support orders. The child support unit continuously updates its operational manuals and is developing new training initiatives with an emphasis on utilizing positive behavior changes to improve outcomes for families. So I just wanted to touch on that because a lot of folks don't know that child support is also a part of probation. Now, the implementation of evidence-based practices started just prior to the pandemic. However, the pandemic's restrictions did not impede our progress with implementing evidence-based practices. We were swift to create guidelines that enabled officers to stay in contact with their clients. We found new and innovative ways of conducting the work that we do. Curbside visits. We'd come out to the house and ask the client to step outside, respecting social distancing. We've increased our utilization of virtual tools such as Zoom and Team and other virtual platforms. We've had a virtual court, including virtual drug court. Drug testing protocols were developed to assist in addressing the needs of our high-risk clients with substance abuse issues. And we've even held some in-person contacts with our clients respecting social distancing. So I'll just conclude by saying that consistent with the judiciary's criminal justice reform efforts, probation has taken a look at the science on effective supervision practices and creating behavior change. And we are now focused on addressing the cycle of incarceration and reducing recidivism rates. The trail them, nail them, and jail them approach has proven to be ineffective at accomplishing this. Probation Services is now intentional about providing a foundation that will assist clients to realize and act on behavior changes that will positively impact their chances for success while on probation and beyond. In probation, we have one of the greatest opportunities to really change lives and to improve our communities. So I think that's my 5 minutes. And I would ask that Lisa, if you could place our web link in the chat for individuals who would like to learn more about probation services.
We certainly will share that link. Thank you, Maurice. We have one question, which I'm just going to note is a broader question about reentry. Maurice has in part talked about the services that clients are provided, but DCJ and the council will consider whether that's a topic for future programming. So I just wanted to acknowledge the person who raised that issue and turn to our next speaker, the Vice President and Assistant General Counsel for Legal Services of New Jersey, Akil Roper, who's going to talk briefly about expanded access to expungements, which really is an ongoing area in the broader criminal legal system reform happening in New Jersey.
Good afternoon. Thank you, Lisa. I will try to be brief. I know the hour is late. Thank you to Mr. Burrell and the Human Relations Council, Judge Grant, the AOC, Division of Criminal Justice, for the invitation, esteemed panelists and all attendees. As Lisa said, my name is Akil Roper. I'm a vice president here at Legal Services of New Jersey. We provide legal services to low-income folks across the state who are unable to retain lawyers based on their financials. So we're talking today about reform, and real reform requires a lot of stakeholders, the people you've heard from today, many others, you, everybody, frankly. But I'm going to talk for a few minutes about expungement, which, as Lisa notes, is one piece of the puzzle of criminal justice reform that we're talking about. And I'm always happy to talk about expungements because in the face of some of the things we've talked about today, mass incarceration, in the face of disproportionate impact on minorities of the criminal justice system, I've seen it. I've seen expungement provide life-changing opportunities for people to get a fresh start and achieve some degree of fairness in the job market. Opportunities which many legal services clients and their families desperately need. Opportunities which disproportionately seem to evade people of low income and communities of color. So expungement is sort of a chance to talk about the other side, right? To a certain extent, what's on the other side of the criminal justice system? So we all know about collateral consequences. I'll refer to them as direct consequences. Folks who are denied opportunities for employment, denied opportunities for housing, education, simply because of a past record of criminal justice or juvenile justice involvement. And so expungements can limit these consequences by removing someone's records from public view. So the sheer record itself can't be used against them. So earlier this year, effective February 15th, there were a number of significant changes to the expungement law, which resulted in expanded eligibility for those who with criminal justice involvement to expunge. And we'll talk briefly about what I consider the most impactful changes in the law. We'll talk about what we refer to as clean slate expungement, the e-courts electronic filing system, and then automated expungement process for marijuana-related offenses and beyond what's next. So clean slate. Legal services in New Jersey have been helping individuals expunge their records for decades, and during that time, we've advocated for and seen improvements to the statute here and there over the years. And I can share with you that clean slate is easily one of the most significant changes in the law. And right now provides a pathway for record clearing for many people for whom it was previously unattainable, which is no small feat because, as a judge mentioned, drug court expungement allows many people to expunge their records. This goes a step beyond. Under the clean slate provision, individuals who have remained offense-free for a period of 10 years may be eligible to expunge their entire record of convictions. Only those who have been convicted of the most serious offenses would not be eligible for this relief. Again, this is life-changing relief for folks. And in practical terms, what this means is that those who would have faced great difficulty and discrimination in the employment market due to multiple convictions on their records, even from decades ago, can now get a fair chance at employment and occupation licensing opportunities. It's pretty major. Electronic filing, another significant change, this time in the process. The court has developed a new online portal for the electronic filing of expungements, which has facilitated filing and service in one streamlined application and also provides for the retrieval of records from several statewide databases. Previously, an applicant had to navigate a multi-step process, gathering their criminal records, determining eligibility, drafting an expungement petition, filing it with the court, then serving a long list of parties by certified mail, responding to objections, and then potentially starting the process all over again if there was a misstep during that process. So for those who are unable to afford lawyers or find legal services providers to help them, it was often a very difficult task and a very discouraging process for folks. The new electronic system embraces technology advancements and confronts a number of those barriers to the traditional paper filing process, essentially making it more accessible to pro se filers and even those who are represented. Automated expungement. The new law goes a step further and now provides for automated processes for expunging certain records. This is an important step, again, because of the numerous barriers to expungement under the petition-based process. One study even showed that only 6% of those eligible for expungement actually received one. So now even those who were unaware of the right to an expungement or unable to afford an attorney to assist them through the process, or simply were unable to go through the process on their own, but nevertheless have their records expunged without having to file a petition either manually or electronically at all. The new law also recognizes the recent legalization and decriminalization of many marijuana offenses and provides expanded opportunities for expungement there as well. So the court continues the automated expungement of decriminalized marijuana-related offenses. And as Judge Grant stated earlier this morning, have already expunged some 360,000 records, and that's major. So for those who records have not been expunged through this process yet, there is still an expedited pathway for immediate expungement of these offenses using the electronic-based petition-based process through e-courts. And so the law also creates a task force, which is now looking into the development and implementation of an automated clean slate expungement, where an individual's entire record of convictions can be expunged. We talked about clean slate, how it's been a great advancement in terms of the petition-based process. Their process now is going to be developed where that will be effective in terms of automated process as well. So we'll see a lot more folks eligible for expungement and getting their entire records cleared. It is something that we are continuing to look forward to, and we're working with the courts and with others to help move this work and have a great impact on those who need it the most. So in closing, always happy to work with the courts, always happy to work with others on these initiatives. On behalf of myself and the clients we represent, we're proud of the work that's been done and prepared to offer perspective to move things forward. Also, it's been echoed, it's not a perfect system, but we are standing ready to help push these initiatives. So thank you to all those participating. Thank you to our guests. Thank you to all of you. Again, I appreciate it. Many thanks.
Thank you as well. So as we wrap up today's presentation, I just want to make a few remarks about the judiciary's ongoing community engagement and general community outreach regarding criminal justice reform and these other areas of reform within New Jersey's criminal legal system. Leveraging the judiciary's longstanding community engagement, I'll call it infrastructure, particularly working through the vicinage advisory committees on diversity, inclusion, and community engagement. The judiciary remains engaged in a robust, ongoing general community outreach project to ensure that members of the community are aware of the criminal justice reforms that took effect January 1st, 2017, and the realities of our current justice system. To that end, from fall 2017 through March 2020, at the start of the pandemic period, if you will, through a combination of 3 different aspects of outreach, we have reached at least 95,000 members of the community to communicate the message of CJR. This has included a combination of literature distribution, infomercials, if you will, at the start of other court-produced community education programs, and full programs such as today's. So if you are connected with a community group or other entity that might like either to receive print or electronic informational literature or receive presentations such as today's program, please reach out to me. I will include my contact information in the chat as well as in the follow-up information that we provide to all of the conference attendees. So on that note, I am going to conclude my facilitator role and turn the program back to HRC Chairperson Ashton Burrell to close out the conference.
Thank you, Lisa. And I think we definitely have to give a big thank you to Miss Lisa Burke for all that she does, all that she's doing, and her role in just making sure something like this helps happen. Also want to thank Mrs. Tanya Hobson as well, and her whole team. Also want to thank Claudia for all that she does. Claudia has been great. Claudia Dimitro, I'm sorry. She's been great, and she's definitely make sure all the information gets out, and also someone that should reach out to know about our HRC meetings and things like that, which I encourage everyone on this call to attend and join us. I also want to thank Karen Paulson, who is our secretary for the State of New Jersey's Human Relations Council, as well as our vice chair, Yumiko Mishima. They phenomenal team, and the rest of the HRC advisory committee, and everyone that comes out regularly to our meetings to make sure everything is going accordingly. Also want to thank the panel for today, the education that they provided to everyone and provided to myself has been phenomenal. And this is information. It's crazy to think that this information is that I just got this for free. So, you know, with me getting that for free, I think it's important for us to remember some of the things that were also said within this chat. Prosecutor McRae Webb says something very important, and I think that we have to definitely pay attention to helping people so some of them don't even get in the system. You know, so making sure that we take this information that we receive and people that was on this call, we provide it to them. You know, if you have a school in your area or things like that that you're connected to, you know, get this information to them. You know, this might can go out in school emails and things like that. There's children that could use this type of information. You know, there's kids that need to be use this information already because of their situations, or a parent or somebody that can use this information that they're not aware of. You know, I was talking to a gentleman the other day who had a gun charge, but he's not allowed to work in the education field. And I mean, his gun charge was because he had to carry it of the area that he was in during the time that he was in his area. There was a lot of activity that you know made him think that that would protect him, and it actually cost him a lot of opportunities. So programs that we talked about today can actually help, because I think a lot of times the problems that we talk about with some of the youth, they have to hear from people that actually been through some of the things that they're going through and experiencing. Just like I think a lot with everything. Just like someone said earlier, we have to have people that are actually in these jails, in these systems, to be present at these discussions. You know, if we making decisions on people and things like that, we need to bring the people that the decisions is being made on to the table, so that every view is understood, respected, and hopefully the best decision and outcome can come from that. So I want to thank everybody as well for joining us, and definitely we want to make sure that we also holding everyone accountable. These resources that are provided to these people, we want to make sure that when people are reaching out to these resources, the resources are returned back to them. You know, I know, for example, sometimes people were driving with vehicle problems, you know, and the line to the DMV, you know, at a certain time, if you weren't there by 6 a.m., you know, you were done. You know, you definitely weren't getting in there that day, you know, and depending on the person's situation, you may have multiple get to school or certain things like that. It wouldn't allow the time to do those type of things. So the work that we're doing here is so important, and I want to thank everybody for their continued work, and I hope that you continue to do work. I'll also leave my information in the chat as well if anyone wants to reach out, and thank you. And also, everyone get home safely. Well, some people may be home already, but everyone be safe. Have a happy holiday. And we look forward to seeing you guys join the New Jersey Human Relations Council as well for our meetings that are coming up.